parting of the ways. And the second point is the use of the word decide. If TRG decide not to use EMFC. So it's clear from that language that Mr. Addington knows he is putting TRG to a decision. And in my respectful submission, the only logical basis upon which TRG could have been asked to make a decision was that something material had changed in EMFC's position. If nothing had changed in respect of what EMFC was prepared to do, there would, as a matter of logic, be nothing TRG to make a decision about. And the fact that Mr. Addington understood he was putting TRG to a decision is hardly surprising, given the terms of his email, and given the terms of what he said earlier in the conversation, which is that he can't work with investigators. So, and it's those two communications, my lord, the email and that telephone conversation, in which TRG say that EMFC evinced an intention not to be bound by a condition of the contract, or alternatively to perform the contract in a substantially different manner to that which they were obliged to perform it, which was in conjunction with investigating.
Mr. Allen, you're dropping your voice slightly. I think it may be 14 months of Zoom hearing.
Yes, it might well be. This is the first time I've physically been in the courtroom since the trial in this action below. So this is since March.
Goodness.
I know, one can't help but think of the day when judgment was given in this. I think it was literally the first day of the full lockdown. It was quite a moment, wasn't it?
It was quite.
Anyway, that's not a useful use of time.
Don't project too far. Remember all the news items about how far COVID can go. So just
Yes,
mid-range.
No spraying. Quite. So that's the evidence as to what was said.
Yes.
By TRG. Now, as to how it was understood by TRG, that's dealt with at paragraph 51
Of the judgment.
Of the judgment.
Yes, back to the judgment.
Paragraph 51, the judge notes that there was following the conversation we've just been looking at the note of, there was a conference call within the defendant's management structure. So that was Mr. Scott, Mr. King and Mr. Jarrett. Mr. King gave evidence at trial.
And this is Mr. King's statement.
Yes.
With the correction that you mentioned earlier.
It is, and I was going to ask the court, please, to read the statement a little bit more widely than paragraph 76, because the judge he cites this seemingly with approval. There's no suggestion anywhere in the judgment that the judge doesn't accept any of Mr. King's evidence, wherever Mr. King's mentioned is in approving terms. So the judge, in my respectful submission, is accepting this evidence. And if one looks at the first line of the extract, Mr. Scott and I held a call with Rob Jarrett and Lisa Kellett. We explained the situation. You can't understand what evidence this is giving unless you understand the situation referred to. So it incorporates what was said earlier in Mr. King's statement. I'd just like to invite the court to look at that. And that is at page 164 of the binder. And this section is dealt with from paragraph 68 through to 76. And I would just invite the court to read that.
Right.
And you've seen paragraph 76, the correction. That
Yes.
not prepared to come, which of course flows naturally from paragraph 71, which is important. Which Mr. King's evidence was that Mr. Scott told me Mr. Addington said TRG must choose whether to work with Investec or EMFC, not both, because EMFC would not work with Mr. Green. No one from EMFC was coming to Cape Verde. And if TRG decided to proceed with Investec, EMFC would refund all fees paid. So that is what TRG's understanding was, what was being said to them. And in my respectful submission, that is a objectively reasonable view of what is being said to them, given the evidence that I've just shown to this court. And the judge, again in my submission, accepting TRG's evidence on this point. He cites Mr. King's written statement without criticism, without any suggestion at all of not accepting any part of this evidence. So that's the evidence that the judge accepted. And that's the context of the choice, in inverted commas, which TRG was presented with a matter of hours before getting on a plane to a series of crucial fundraising meetings. EMFC was saying it couldn't work with Investec, and so for EMFC to remain involved, Investec had to be removed. Now, just turning to what the judge says about this, paragraph 51, the judgment over the page. And the judge says, in my judgment, the phrase he was trying to hold a gun to our heads and force TRG to abandon Investec is an important one. It's consistent with what I've said so far about the content of the 16th January email and subsequent conversation. Emphasises the point I'd already made that no one understood that down to that point, Mr. Addington had evinced an intention no longer to be bound. Now, with the greatest respect to the judge, I suggest the only way to understand what he says there is as evidence that the judge wasn't considering the full suite of EMFC's contractual obligations, and specifically wasn't considering EMFC's obligation to work in conjunction with Investec. The judge accepts Mr. King's evidence as to what TRG perceived, but then says that evidence shows that no one understood Mr. Addington had evinced an intention no longer to be bound. But that evidence shows that TRG's understanding about Mr. Addington's position was that EMFC wouldn't work with Investec, and they had to choose between them, and that was a position in my submission that was patently not in compliance with EMFC's obligation to work with Investec. The judge said because TRG understood itself to have a choice as to how to proceed, EMFC couldn't have renounced the contract. And we see that most clearly at paragraph 54 of the judgment. The judge says, in my judgment, the content of the last conversation, consistent with my view about what had gone before, the defendant had not understood the claimant to be renouncing the contract. Had they done so, the defendant would not have been forced to make a decision. The decision would have been made by the claimant. Again, the greatest respect to the judge, I suggest that makes no sense when measured against what EMFC was actually saying. I say the judge fell into error in two respects here. So first, and this is a point I make in my skeleton argument, the judge focused here and a number of other places in the judgment about whether TRG understood EMFC to have renounced the contract. But that, of course, is the legal question, whether there's been a renunciation. The prior relevant factual question is what position is being presented to you as a matter of fact. And that's, with respect, is what the judge should have focused on first. So I say he fell into error in that respect. And secondly, he was wrong to find that the fact that TRG was presented with a choice meant that EMFC could not have evinced an intention not to be bound by its contractual obligations.
But another way, they're renouncing the contract to work with Investec.
Yes, quite, my lord, yes.
In your case.
there's a number of observations made about the fact that if you're given a choice, it can't be a renunciation. Well, first, there's always a choice when there's a renunciation, because the party has a choice whether to accept or reject the repudiatory breach. So there's always a choice in that sense. But when you're describing what was presented to TRG as a choice, that's an inaccurate description. A choice given to someone with a gun against their head is not generally considered to be a real choice at all. I believe it's generally called Hobson's choice.
So which paragraph are we looking at, please, in the judgment?
54.
54. Thank you.
Had they done so, the defendant would not have been forced to make a decision. The decision would have been made by the claimant. And for the reasons I've just been outlining, I say that that is wrong. TRG had a contractual relationship with Investec, which it couldn't fairly be asked to breach by removing them. But more importantly, and this is the point Lord Justice Lewis just made, there was the benefit of a contractual obligation that EMFC had to work in conjunction with Investec. So to say it couldn't do so, wouldn't do so, was breaching that contractual obligation. And what the judge appears to have done, in my submission, is to form the view that because EMFC didn't say, well, we're not going to carry out any work under any circumstances, it couldn't have renounced the contract. And that's not right, that's not the legal test. Contract is renounced if one party makes clear that it won't comply with a contractual condition, or it will only perform in a manner substantially inconsistent with contractual obligations. And that's a classic statement in the Ross Smith case, which for the court's note is at tab 3 of the authorities bundle, and just to do the side marking, 49 bundle. Page 49 of the authorities bundle, and letter B.
Sorry, because that's page 44 of the...
49, my lady, of the authorities bundle. And this is the classic statement that's recited in various textbooks. And this is at B. I do not say what is necessary to show the party alleged to repudiate should have an actual intention not to fulfil the contract. He may intend in fact to fulfil it. He may intend in fact to fulfil it. May be determined to do so only in a manner substantially inconsistent with his observations and not in any other way. And what EMFC was doing...
I think the more, forgive me for interrupting, I think the more classic statement is that which you agreed and the judge recorded in paragraph 4, which is depriving of substantially the whole benefit which it was the intention of the parties he should obtain.
Yes, it's either breach of a condition, full
Yep.
stop, or exactly as my ladyship
Yep, all right.
described. So, again, the judge says, let's come back, the judgment, paragraph 48. Again, this is the same subject about the fact of a decision, meaning that there couldn't have been a renunciation. So paragraph 47, the judge discusses the note that we looked at a moment ago, reflects what Mr. Addington said. He was saying the decision whether to continue with the claim was for the defendant to decide. Makes no sense unless understood having that meaning. This is an important exchange because it's consistent with the conditional terms email, shows that neither party understood it in any other terms. It's important because it shows at the end of the conversation neither party considered that the claimant and Mr. Addington had an intention no longer to perform its obligations under the agreement. It's the same point. The fact that it was presented as a Hobson's choice does not make it, or does not render it incapable of being a repudiatory breach, or anticipatory repudiatory breach, which is what it was. And there are a number of other places in the judgment where in this passage between paragraph 48 and 55, where the judge falls into what is essentially a repetition of what I say is the same error. example is paragraph 50, the paragraph we were looking at earlier, where it's recorded that Mr. Addington did say that nobody would be going to Cape Verde from EMFC, but it was not understood to be repudiatory, as apparently what followed in the terms of the note itself. The action that was proposed to be taken by following the conversation. Again, at the same point, the action to be taken following the conversation was a choice. TRG, therefore, it couldn't have been a repudiation, which again suffers from the same bad logic in my submission. So in my respectful submission, it's clear beyond any doubt when Mr. Scott stated in the second telephone conversation of that day with Mr. Addington that TRG had decided to go with Investec, that TRG understood that EMFC had stated it couldn't continue to work with Investec and had forced TRG to choose between its advisors. And I say that is clear from the evidence of Mr. King, to which I've taken you, from the evidence contained in Mr. Scott's contemporaneous notes. It was also repeated in the witness statement of Mr. Scott, upon which, of course, he was not cross-examined, so that it has limited weight, but it was there in his witness statement as well, which is at tab 24 for the court's note. And as I've said already, the view that TRG was being asked to choose between its advisors was a reasonable understanding for it to form on the basis of all of the material that was before it, and was an objectively reasonable understanding. Now, it's said against me that the judge didn't find as a fact that EMFC refused to continue to perform its role in conjunction with Investec. And there's one particular paragraph of the judgment that I have to deal with head on in this respect, and that's paragraph 64. So the judge has found that the notes of the conversation are accurate. The judge has found that Mr. Addington did say that no one would be travelling to Cape Verde. The judge has accepted Mr. King's evidence as to what TRG's understanding was. But then at paragraph 64, the judge says, I do not accept the January email as repudiation. It was not a refusal to travel in absolute terms. As I said, I did not accept that in the conversation following, Mr. Addington said no one from the claimant would travel to Cape Verde in any absolute sense. The point being made was that in Mr. Addington's opinion, it was not in the defendant's interest that the claimant should travel to Cape Verde, unless and until the difference between Investec had been resolved. The subsequent call following the internal discussion within the defendant's management shows that to be the defendant's understanding. In my judgment, therefore, the repudiation defence fails. So what the judge appears to be hanging that on is the subsequent conversation as gaining some support for that finding, which in my submission that finding runs contrary to all of the evidence we've been looking at so far. But let's look at the document which the judge relies upon, which is the notes of the second conversation. That's at page 156.
So this is between Mr.
Again, this is between Mr. Addington and Mr. Scott.
Scott.
Yes.
Does the judge rely on the note or on the evidence about the note? Or both?
The judge appears to be relying primarily on the note.
This is 56, 52.
Yes, I'm just turning that back up and forgive me.
Yes, 52. Yeah.
64, the judge.
All right.
64. The judge says the subsequent call following the internal discussion shows the defendant's understanding.
And Addington and Scott give evidence on this?
Scott gives evidence, but is not tested in cross-examination.
Because he doesn't come.
Yes.
But Addington does.
Addington
Yep.
attends trial and gives evidence, my lady. Yes.
Yep.
So the specific point of the judgment where this note is dealt with is paragraph 52. And it is by reference to the note, which is not disputed by Mr. Addington.
Yes, correct, my lord, yes. The next call was by Mr. Scott to Mr. Mr. Addington. Yes, so paragraph 52.
And then he quotes a bit of it, but you're taking us to the full
Yes.
note.
It says, followed the internal call, decided to go with Investec.
Before we get to that note, can I just ask, paragraph 51, the extract from paragraph 76 of Mr. King's statement. We had the email, then the first phone call between Mr. Scott and Mr. Addington. Then we have the discussion internally with Mr. Scott, Mr. Jarrett, Miss Kellett, and Mr. King. And what he says at the bottom, it was agreed that Mr. Scott would contact Mr. Addington to inform him that we would not submit to his ultimatum and we would be proceeding with Investec alone. So that's ambiguous, or is it ambiguous? They're not submitting to his ultimatum, we'll proceed with Investec alone, but could it mean, unless of course the MRF backs down and does go along with Investec? Is it clear that...
Well, what I say
it is.
in the context of the witness statement, which I took you to, I say it is clear because the ultimatum was presented.
Was us or them?
Yes, us or them. The Hobson's choice.
Yeah.
I'm not sure it's Hobson's choice, but it's a...
Not Hobson's choice. Hobson's choice was you got this horse and no other.
Yes, yes. Maybe it's not Hobson's choice, but it's certainly not a choice properly so called. It's a choice in inverted commas.
It's Henry Ford, actually. You can have any car you want as long as it's black.
Black.
Yeah. Well, even that's not a choice.
Anyway, we've got your submission without the analogies.
Yes, I'll drop the analogy.
Okay, so I'm back at the note.
Yes,
156.
So we decided to go with Investec, followed call with the internal, followed call with Mr. Green to confirm. Told we'd be forced to make a decision given depths of feeling from both sides.
Well, just don't run over that. And this, I think, features in the judge's analysis, doesn't it? Told Mr. Addington, we'd be... I'm going to emphasise words. Don't take that as indicative, but it could be said that the following is against you. We'd been forced to make a decision given depths of feelings on both underlying sides. So the judge relies on that, doesn't he?
Well, what I would say is they've been forced to make a decision on the basis of all the material that I've taken you through so far.
What do we know about the feelings of the other side?
Well, my lord, earlier in the judgment, I think my learned friend took you to this earlier, it had been said Mr. Green and Miss Papasava had fallen out.
Yes.
But Mr. Green had always said that he could work and would continue to work with Mr. Addington.
Yes.
So there's no suggestion that anyone, there's no evidence or suggestions that anyone on the Investec side refused to work with EMFC. So there was no evidence at trial to that effect, my lord. So the only evidence as to the decision that TRG was put to was the evidence which I have been outlining over the last...
Well, there's evidence, wasn't there, that Mr. whatever he's... Forgive me, Mr. Green. Do I mean Mr. Green? Yes. It said he could continue to work with Mr. Addington,
But
but
not with
couldn't
Miss
agree
Papasava.
to work with Miss Papasava. And I mean, this note makes it very clear that, well, certainly it was said that the need to make a decision was driven by the differences on both sides, the depth of feelings and the differences between Investec and EMFC.
My lady, there certainly had been feelings on both sides, but there was no evidence at trial that Investec had ever said that they could not work with EMFC, full stop, or that they were pulling out many of their obligations.
No.
And I
Well, we don't have to take this at face value.
but if one looks over the page, which is a continuation of this note, and then a later call.
Before we leave this note in 156, it says we've been forced to choose, we've been forced to make a decision, given the depth of the feelings from both sides, taking into account the long-term view we want Investec. Decision to ask RA EMFC to step aside. A decision to ask, not a decision
Acceptance of, not acceptance of your decision.
If legal advice had been taken, doubtless that would have been phrased differently. But one of the points which the judge fairly makes, and which I pray and aid, is that no legal advice was taken, so no legal analysis was applied to the situation by TRG.
But this is not a question of legal analysis, it's a question of the facts. often better to, you get the artifice if you're looking at legal advice. This is the position on the ground.
Because RA didn't say, right, it's over then. What he said was he asked questions. Why? Was the work okay? Can Investec do it? And it was left saying, I assume that's Carr,
Yes, it should. I checked
early
the notes.
next week, once I considered financials. So it looks like we don't like them anymore. You've got to choose. Mr. Scott coming back saying, well, if we have to choose, we're going with Investec. We'll ask you to step aside. And Mr. Addington saying, why? We're better than Investec, and so on. And then it was left saying they'd discuss it next week.
Well, they'd asked them to step aside, but on the basis of all that had gone.
Yeah, I
before
accept
them.
that. But at this stage, they haven't finally divorced. There's still one more trip to the Marriage Guidance Council.
Well,
We were sitting in a family case yesterday, and it's, the Lord is still.
the analogies we've had today, it's extraordinary. But just can I ask just to read the end of this note and the following clause? Because 157, we have Mr. Addington repeating his offer to return all fees and walk away, which again I say is consistent with the position of EMFC pulling out. And just to, in case there's any doubt about the fact that it was EMFC pulling out, we see Mr. Addington describing it in that way himself in the next call, where he said, I need to pull out. I can't work with their sexist approach, have no regrets, strong feelings. So again, Mr. Addington there himself, the way Mr. Addington has viewed that situation is that they need to pull out. That's what's happened. And that they can't work with Investec. And I say that all of that particular, that last very important part of the communication is consistent with what had gone before. It's consistent with the judge's acceptance of TRG's evidence, and TRG's position and understanding was a reasonable one. And the true position is that EMFC did make clear that it couldn't continue to work with Investec, and that was a breach of either of a condition or it was substantially different performance to that which they were obliged to provide, and on that basis renounced the contract. Unless I can assist.
Anything else on
No, thank you very much. Thank you.
Anything else? Thank you very much, Mr. Allen. So now, Mr. Sweeting. Let's see. I'm just wondering, how long do you think you're going to be now, Mr. Sweeting?
I think I'll finish by close of play on repudiation. Hope so.
Well, in that case, should we have a quick word?
Yes. So. Yeah. We'll rise for a moment.
wear masks? Is that the rule? I mean, I did that in this court ring. I'm just not sure what the actual rule is.
Not going to be anyone's picnic. I think originally it was those who had a speaking part.
Right.
What actually happened was that if you weren't speaking, and everyone said you can't wear glasses because they stick up.
Yes.
I mean, I can do without glasses.
Yeah.
Seeing.
Yeah.
So I don't want to see.
Exactly. That sounds like a good.
Yeah, I do occasionally.
I should. I think maybe they're talking about whether they can sit late and get this done today.
Yeah, maybe. Yes, that's the other prospect.
I mean, I have to be away by about 5:45, but it's not going to take that long. Yeah, very hot. I haven't noticed the cooling yet. It's so hot now.
Mr. Sweeting, we've had quite a long day, and what we're minded to do, we don't think we're going to finish, knowing the points that are concerning us, and having heard Mr. Allen's submissions on repudiation, we don't think we're going to finish this afternoon. We think it's unlikely we'll finish your submissions this afternoon, and we let alone get to Mr. Allen in reply. So we're minded to rise now and resume it tomorrow morning at 10:30, and that will give you all of the chances to reflect on these, where we are with this, and we hope that that will enable the matters to be concluded more efficiently.
Yes, well, some time often means that one can go a bit more quickly and more succinctly.
Yes, well, thank you very much. All right, so we'll rise now. Look forward to seeing you all tomorrow at 10:30.